All right. Good morning, Chair Postman, Member Garrett, staff, and those attending. Thank you for your patience getting the lobby open today. It is open and the recording has begun.
Great. Good morning, everybody. We will call to order the Washington State Liquor and Cannabis Board meeting for Wednesday, April 27th, 2022. Our first item on the agenda was approval of meeting minutes from the April 13th meeting. We're going to have to postpone that approval to a later date, which moves us to an update from Chandra Beatty, our Director of Enforcement and Education on Retail Security and Safety. Director Brady.
Good morning, Chair Postman, Board Member Garrett. As you know, I've been working with internal and external partners to make sure we provide support to our cannabis retail licensees as the incidence of violence related to robberies has increased. Within the next week, we'll be announcing a partnership with a statewide crime prevention association that allows us to provide training to retail licensees and their employees, and also lead best practice discussions from a SUPTED perspective. SUPTED is crime prevention through environmental design. In addition, we'll be announcing a contract with an established, experienced security firm that will be available to our licensees to assess physical security and employee safety and make recommendations specific to licensee locations. Both of these options will be made available at no cost to our licensees and aren't mandatory. And as you expressed an interest in providing resources and support to our licensees, we'll meet that need.
That's great. Sense of timing when the first one of either the crime prevention CPTED sessions might happen or the physical security assessments? How close are we?
So the training sessions are scheduled at this point, and this will be all solidified before we make the formal announcement. But at this point, we hope to start the training sessions at the end of May.
Oh, great.
Have those all scheduled out. We're looking to do 10 to 12 of those so that we try to make sure that schedules will allow for licensees or their employees to get to one of them. And then those should start the last week, maybe the last 2 weeks of May, and then the physical security assessments should be available mid-May to start happening. And we're going to do 3 phases of release on those. And so for the security assessments, we're going to start those in the areas that were most impacted by the recent robberies. And those have been identified as King, Snohomish, and Pierce. And then we're going to open that up to the I-5 corridor, and then we'll open it up to statewide folks. And it'll be open to everyone the whole time, but we'll be prioritizing those groups just in case there's a bunch of applicants. We'll prioritize the folks that have seen the most incidents of violence and robberies in their area. So that's how that'll roll out.
That's great. And on the physical security piece, the plan there is that there'll be consultant hired at the state's cost available to any licensee to visit their facility.
Yeah, that'll be an on-site physical security assessment to give them recommendations. And again, these are completely voluntary. There's no accountability. Our interest isn't in saying you need to make sure this happens by this time. That's not part of the deal. It's just to give them another look at some of the things they could do.
It's a service that we'll be able to make available at no cost, which is one of the things we heard from folks. So I hope that people will be able to take advantage of that.
I do as well.
Yeah. That's great. Okay. Member Garrett, any questions before we let Director go? No? Okay. Thank you. Really appreciate that and look forward to the more detailed announcement coming soon and sitting in on at least one of those sessions, this SUPTED session. That was a pretty interesting thing as I started to read that website and things.
Yeah, some of the best practice recommendations will be from that perspective, and then they'll be obviously doing safety and security training as well.
Yeah, terrific. Okay, great. Thank you for the good work, Director. We will move now to cannabis-related rulemaking and be joined by Jeff Kildall, the Cannabis Policy and Rules Coordinator. Good morning.
Good morning, Chair Postman and Member Garrett. Today, I would like to request your approval of a CR 105 expedited rulemaking package to implement second substitute House Bill 1210 entitled Replacing Marijuana with Cannabis. which was passed by the Washington State Legislature during the 2022 legislative session. In passing this bill, the legislature found that the term marijuana in the United States has discriminatory origins and should be replaced with the more accurate scientific term cannabis. For this reason, the bill replaces the term marijuana with the term cannabis throughout the Revised Code of Washington, including Chapter 6950 RCW, the Uniform Controlled Substances Act. The bill also directs the LCB to replace the term marijuana with the term cannabis throughout the rules of the Liquor and Cannabis Board through the expedited CR 105 rulemaking process. So the purpose of this CR 105 expedited rulemaking is to replace every occurrence of the term marijuana with the term cannabis throughout Title 314 WAC, the rules of the Liquor and Cannabis Board. No other changes are proposed by the LCB. Under the Administrative Procedures Act, Chapter 3405 RCW, the expedited rulemaking process differs slightly from the regular rulemaking process. The expedited rulemaking process begins with the filing of the CR 105 expedited rulemaking form instead of the usual CR 101 form filed in regular permanent rulemaking. After filing of the CR 105, a 45-day public comment period opens on the rule proposal. At the end of the comment period, the permanent CR 103 rulemaking order is filed if no substantive changes have been made to the rule proposal. And under expedited rulemaking, a public hearing is not held as part of the rulemaking process. So if approved today for filing, a 45-day public comment period on these proposed rule amendments will extend from the publication date in the Washington State Register, which will be on May 18th, 2022, until July 2nd, 2022. And under this timeline, we would tentatively bring a CR 103 package to you for consideration on July 6th, 2022, and the rules would then become effective 31 days later on August 6th, 2022. And so this ends my presentation on today's rulemaking proposal. So can I answer any questions?
No, I think did a good job setting this up. I'm glad we're doing it. It's just one more step in the effort to, I guess, be honest about some of the history of these things and to take action. So thanks for your work on it.
Thank you.
Okay, and then we'll entertain a motion to approve the 105 for implementing second substitute House Bill 1210.
I move approval of the CR 105 implementing 2022 replacing marijuana with cannabis.
Great, and I second, and then that's approved. Great, thanks, Mr. Kildall. Move to the alcohol side now with Audrey Vasek, our policy and rules coordinator on that side. Good morning.
Morning, Chair Postman and Board Member Garrett. Thanks for the opportunity to be here today. I'm requesting approval to file a CR 101 pre-proposal statement of inquiry related to implementation of 2022 legislation, Senate Bill 5940. So for background, this bill created a new endorsement allowing breweries, wineries, and distilleries to contract with each other and with other non-liquor licensed businesses if the contract does not include alcohol products to provide certain packaging services. So this includes things such as canning, bottling, bagging, mixing, repacking, that sort of thing. The bill takes effect on June 9th, 2022. A new rule section and revisions to existing rules are needed to align agency rules with the new law and help inform licensees about the availability of the endorsement and its requirements. So if approved today, I'll file the CR 101 with the code revisor, send notice to GovDelivery subscribers, and the informal comment period will begin. Notice will be published in the state register on May 18th, and the informal public comment period will end on June 17th. We anticipate bringing a CR 102 to the board to consider on July 6th, and our target date for bringing a set of final rules to the board is August 31st. So that concludes my presentation on the CR 101, and I'm happy to answer any questions.
Seeing no questions, we will take a motion to approve the CR 101 for implementing Senate Bill 5940, Contract Packaging Services Endorsement.
I move approval of the CR 101.
And I will second, and so that's approved. Thank you, Ms. Vasek, and thanks to Senator King for sponsoring that bill and working with us to get that done the last session. And now, Ms. Vasek, back to you to introduce our public hearing on axe throwing at liquor licensed establishments.
Thank you, Chair Postman. So I just want to provide some brief background on this project prior to the public hearing. For background, this CR 102 rule proposal was filed on March 16th following a collaborative rule development process that considered input from public health and prevention groups, axe throwing businesses, liquor licensees, and other interested members of the public. The agency held a virtual listen and learn stakeholder engagement session on February 3rd, 2022 to gather feedback on conceptual draft rules. And at peak, there were 65 individuals in attendance at that session. The feedback we received during that session was considered and incorporated into the proposed rules, and that feedback was also provided as an attachment to the CR 102 memo. So in summary, the proposed rules that the hearing is on today would require licensees to offer that want to offer axe throwing to create a safety operating plan that includes two main components: protocols for monitoring patron intoxication and consumption of alcohol, and a floor plan designating consumption areas where alcohol is allowed, as well as identifying the axe throwing areas where alcohol is not allowed. The proposed rules also outline how to request a change in safety operating plan and include reference to penalties for non-compliance. They do not require that businesses use any specific methods or materials to construct barriers. In terms of timeline, the formal public comment period, closes at the end of day today, April 27th. We've received 3 email questions and comments related to this proposal so far in support. So after the comment period closes, the rule drafting team will meet to consider those comments, and if no substantive changes need to be made to the proposed rules, at the earliest, the CR 103 or final rules could be brought to the board on May 11th. And if they are approved on May 11th, then they would go into effect on June 11th. So that concludes my presentation, and I'm happy to answer any questions.
No questions from me, none from Member Garrett, and nobody has signed up for our public hearing. So just pausing for a second to see if I missed anything. It doesn't sound like it, so we will close the public hearing. Thank you, Ms. Vasek. Can you just tell me then, what is the next step for here now that the hearing is closed?
Yeah, the next step is we'll meet with the project team to review the 3 email comments we did receive, and then work on preparing the CR 103 package. So the earliest that could be brought to the board would be May 11th.
Okay, great. Well, we'll see you then, if not before. Thank you for this.
Thank you very much.
We are to the part of the board meeting for general public comment. Citizens are invited to address the board. Everybody will be given 4 minutes. I, as always, urge people to be mindful of their time. Dustin will remind you when you have 30 seconds left. At the end of that, we will really ask you to wrap up right away to keep it moving. We ask you to state your name and affiliation for the record when you begin. As always, I'll urge everyone to be civil, and if possible, we'll try to avoid personal attacks. It sometimes takes a second to find you on the screen and connect you, so be patient, and as we will as well, your time won't start until you're on and working. So the first person I have signed up is Libby Haynes Marshall.
Good morning, Chair. Libby did register to speak, but is not online with us today.
Okay, thank you. Next person I have signed up is Christopher King.
Hello, I'll be ready in 1 second. I just didn't want to unmute too early here. Can you hear me?
I can. Go ahead.
Yeah, very well then. Okay, guys. Yeah, I was going to go. I had a prepared speech and all that, but I'm not going to do that. I'm just going to speak extemporaneously. I want to get a few things straight right now. First of all, I remind everybody that I am currently a hearing officer based on my civil rights experience. I am a hearing officer for government in a related field to civil rights. Okay, that's what I went to school for. All right, that and investigative journalism, and that's a fact. Okay, so with that in mind, let's move forward and talk about some of the things that are before us today. First of all, I made a mistake last week or 2 weeks ago when I said that we needed to run this analysis through a compelling governmental interest window and strict scrutiny analysis. That's not true. With respect to Libby Haynes, at least, all we need for her is a rational basis test, okay? Because you can easily engage in rulemaking, as you always do, and make the rule that if you went through the gauntlet and you got your lottery pass, you succeeded at that, and what under LCB's financial chair, Darryl Powell, called a fraud lottery. But if you succeeded at that, and then you didn't get your license because of a reason that's been taken away, then the rule should simply be that you go to the front of the line with these equity, licenses. This is simple, okay? And that is a race neutral criteria. That's what that's known as. You can ask your lawyers, they'll tell you I'm right. So, Pepper, God damn it. Sorry. Anyway, next. The whole purpose of this thing has to be to respect and honor those who built the industry. And that's the OGs. This means not just the black OGs, but the white OGs. My expert witness with John Novak and Sidra Raylene Hall, Frank Giese. I'm sure the LCB knows him. He was a pioneer too, all right? And these people never got a shot. They got two-stepped out by 502 and 5052. They come first. And these Johnny-come-latelys, they come second. Now, how do we deal with the Johnny-come-latelys in a civil rights framework for analysis? What happens then is we turn to the compelling governmental interest application, where you have to show that there's a compelling governmental interest in helping these blacks and OG whites who helped make the foundation of the legal cannabis market here. And that's a fact. We owe them. So given the fact that no blacks made it through, yes, the first several licenses should go to blacks. And then after that, you develop a ratio, 1-to-1, whatever you do. But that's the civil rights analysis, guys. I know it well. As I mentioned before, I studied under Ted Mearns. I was his law clerk for most of a year. The guy did the whole he was influential in doing Cleveland's desegregation. Okay, he was like preeminent civil rights scholar. All right, so, whew, good God. I mean, I've worked with Bill Kunstler on a case once. Okay, so I'm not all of that, but I'm enough of that I should command respect and not rolled eyeballs. So next, I won't tolerate any anti-Semitism here. And I want to talk now about who controls the narrative in all of this, because everything that John Novak and I are talking about, the lack of testing, Ian Eisenberg wrote me, I published the email chain between us. He started testing in 2018. Everything that Novak and I and Sinjo Hall are talking about. We had a summit conference with you guys yesterday, which went nowhere, but we'll talk about that later. We were on it. And so Ian eventually, as you can see, he somehow decides that all of a sudden I'm bullshit, quote unquote. And I'm like, how am I bullshit?
Yeah, 30 seconds.
Okay, yeah. So that and then also the way that everything Miller Nash said about cronyism and all of that, that's something that Novak and I are talking about. And we're not attacking Ollie Garrett. What we're saying is that if the only way that people of color can get licenses is through being personal friends of Ollie Garrett, then there's a problem in the system, and that system needs to be examined. I'm all about proud black women. I've got plenty of them in my family. I'm sure you guys know who they are. You've looked at my background, okay? So, it's not about putting down. What about lifting Libby Haynes? How about that black woman?
Christopher, that's your time.
Thank you very much, guys. And I encourage you to research what I was saying, and I look forward to working with you in the future.
Thanks. Next person we have signed up is Kevin Shelton.
Am I here? Can you hear me?
I can hear you. I can hear you. Yes.
Okay. Okay, I'm Kevin Shelton, and I'm the founder of Lifetree Collective Garden in Skyway, Washington, from 2011 to 2016. I had 0 violations from any local or state agencies. And first off, I just want to speak, to Ollie and let her know that we're not here to hurt her or personally attack her. My mother is considered a Black woman, so I'm not here to attack her. I just wanted to shed some light, on the violations that were done against me. You guys still have not acquired the PLEA training, so you're still acting with limited authority. We were destroyed financially, some of us emotionally. We have family members, friends, that took the plunge with us and, loaned us money to get started. These people are expecting a return on their investments. Okay. So, the light is not to be just shed on Ollie. The reason we're here to shed the light is, that she happens to be affiliated with the people that done this to us. And all of you guys are profiting off of our downfall. That, it was unlawful. So just to clear that, we're not here to attack the Black woman. We're not here to take her down. If it wasn't for a Black woman like Ollie Garrett, I wouldn't be alive. Okay. But just some of the close affiliations are too close for home. Mr. Buchanan of the Washington State African American Cannabis Association told me on the phone call that he speaks for all of us. I'm here to clear that up today and to say that we're not acquiescent. We speak for ourselves. He can speak for those in the community that wish to not speak for themselves. He has the right to speak for them. Okay, we're here to speak for ourselves, and we want some justice. Where is the NAACP? Mr. Powell called the lottery a scam. You guys are coming out with another one. Where's the Washington State African American Cannabis Association? Where'd those guys at? We haven't heard one peep. We were told that we offended some people during the Senate committee meeting by mentioning some names. And I'm not here to get into the names. You can go and find the affidavits on the record and in the federal court. Okay, we're here to get justice and to speak for ourselves. Mr. Postman, you can make a difference. You can make a difference. You guys can make a difference. But it shouldn't just be to people that are close to you or that can be controlled or managed by you. What is the personal vendetta that you have against the Black pioneers? What is it? Why would you reach around those who helped forge the way for you guys to even get the salaries you're earning now? Why would you go around us? What is it? Be clear with us, okay? We're not here to argue for arguing's sake and to be crabs in the bucket. Look at it closely. You'll find who the crabs in the bucket are. Look
Kevin,
at the
you have 30
situation.
seconds.
Okay, thank you. We just look at the facts. Okay, so no, we're not here on any personal vendettas. We're here for business, and we're here about money. You guys are in the cannabis board. You guys are about the money too, or you wouldn't be here. So you guys have a good opportunity to be on the right side of history. Thank you very much.
All right. That is the last person we have signed up to testify. We do have this time in every board meeting for people to comment. It is your time to say what's on your mind. But I think I also have the ability and the right and an obligation to speak on behalf of this agency. And also just on behalf of the entire group of people that come to these meetings and what we hope to accomplish. I will just say, gentlemen, just because you say you're not attacking Board Member Garrett doesn't make it so. You continually bring her up. You bring up the same issue. She and others have addressed it. to continually try to demonize Member Garrett when she has single-handedly led the effort to make our system more equitable. It just that it's I'd tell you that it's not a convincing argument for me. So if that's your goal, I got to tell you it. And I can assure you that neither Member Garrett or I are motivated by the money that these part-time jobs pay. And we don't make more money depending on who gets a license. So there's the work that's actually been done on the social equity licensing rules, and now that our licensing team is working on and getting ready to go. I just remain super impressed by it. It is a very difficult situation, as I think everyone can recognize. There is just a lot of litigation around these issues on both sides, and so anybody who thinks it's easy, I think that's a short-sighted view of this. The long term is not easy, and so we really need a strategy to make something work. And that's what we're doing. I think we have it. So again, I just always will hope that we can move beyond the personal and talk about the policy, talk about case law if you want. You can criticize us all you want. That's why we're here. That's why you have that opportunity. But I'll just tell you as one member, I'm not moved by the personal, even if you say it's not personal, and then do it. So, Member Garrett, anything you'd like to add?
No, thank you.
The last thing I want to do is I just want to remind everybody that we have a session tomorrow that our policy team has put together. It's a deliberative dialogue on evaluation of THC compounds, and it's going to look at how do you determine and define what is and what is not impairing, which I think we all know runs through a lot of our conversations with the legislature about regulating compounds. And the goal here to get some mutual understanding of how to determine and define that. And so we got some experts coming. I'll tell you, these are not experts who necessarily are going to come and be in complete agreement with what our team looks at and what we proposed last session. So I expect a candid and interesting conversation about that. This is one of 3 deliberative dialogues that we're going to have this year on these subjects, and there'll be all in the general rubric there of THC compounds, but they're going to look at different pieces of it. So it's 1 to 2:30 tomorrow. It's going to be on Microsoft Teams. You can find information on our website. And I just really encourage anybody who is interested in that issue to join us. And see our director, Rick Garza, would like to have a word.
Thank you, Mr. Chairman. The meeting is today, David, from 1 to 2:30.
Oh, that's why everybody's hands have been shooting up.
Thank you.
Should I do that all over again? Today. Sorry, everybody. 1 o'clock today. Boy, I got ahead of myself. I am really sorry about that. Today, in a matter of hours, 1 o'clock till 2:30. Still the same subject. So sorry about that. But yeah, hope people can join. Go to the website, get details, 1 to 2:30 today. Okay. And with that, we're going to adjourn the meeting today. Thank you, everybody.